Aiboan, Vanakkam, Assalamu alaikum, and of course, a very, very good evening. On behalf of AmCham Sri Lanka, it's my pleasure and privilege to welcome you to the 8th in our series of law reviews. And today we're talking about shareholder rights and obligations. If you remember, over the last couple of episodes, we've been talking about corporate governance. We spoke last week about the director's duties and obligations, and today we're looking at shareholder rights and obligations. And we have with us, of course, once again, a very eminent panel of speakers. So without much ado, let me introduce you to your speakers and hand over for this very interesting, important, and of course, timely conversation that we're going to have. Leading our panel, of course, Mr. Nihal Jayawardena, President's Counsel. Mr. Jayawardena is an old boy of St. Anthony's College, Kandy, and he entered Sri Lanka Law College in 1980. He was enrolled as an attorney at law of the Supreme Court of Sri Lanka in November of 1983 and joined the Attorney General's Department in 1984. Mr. Jayawardena was awarded a master's degree in public international law by the University College London in the 1990-91 academic year and specialized in the field of aviation law. Having passed the final examination for the entrance as a solicitor in the year 1991, he enrolled as a solicitor of the Supreme Court of England and Wales as well. Mr. Jayawardena actively participated in the company law reform process from May 1993, which resulted in an enactment of the Companies Act No. 7 of 2007. And he initially functioned as the secretary of a subcommittee appointed to carry out a study into the areas that needed reform, and thereafter as the research coordinator of the Company Law Advisory Commission, working alongside Dr. David Goddard, Queen's Counsel, World Bank consultant, who had a vast experience in company law reforms worldwide. Mr. Nihal Jayawardena also served in the commission appointed by His Excellency the President for the purpose of simplification of existing laws and regulations in the interest of the people. Mr. Hiran D. Alves, Senior Legal Counsel. Mr. D. Alves is a senior legal counsel practicing in Colombo over the last 25 years, specializing in civil and commercial law, financial and securities litigation, and commercial arbitrations. He is a graduate of the University of Colombo and holds a postgraduate qualification from the University of London in international dispute resolution. He is also an arbitrator and a fellow of the Chartered Institute of Arbitrators of London and the Malaysian International Arbitration Centre. Mr. D. Alves is also a member of the Board of Governors of the Sri Lanka National Arbitration Centre and its Honorary Chief Legal Advisor. Ms. Ayomi Aluvihara, Senior Attorney at Law and President Partner, is of the law firm FJ and G. Serums, I beg your pardon, and is the head of corporate law and commercial division of the firm. She has over 20 years of experience in advising clients in the firm in all aspects of corporate and commercial law transactions. Foreign direct investment and infrastructure, capital markets, and banking and finance are focused practice areas for her, and company law advisory work is common, of course, to all these practices. Last but not least, your moderator, Ms. Lalini Parnavithana, also attorney at law. Ms. Parnavithana is a law graduate from England and attorney at law of the Supreme Court of Sri Lanka with experiences in the areas of civil law, and she functions as an academic. She is currently attached actually to the American Chamber of Commerce in Sri Lanka and is the co-organizer and co-convener of this series. Lalini, over to you for what is sure to be a very interesting and insightful conversation this evening.
Thank you, Rai. Welcome you once again for yet another important topic on corporate law. As mentioned, today we intend to obtain a better understanding on aspects related to shareholder rights, duties, and obligations for our expert panel present here, present here. So this discussion will mainly cover an introduction to the concept of shareholder, powers and liabilities of a shareholder as provided in the current corporate law regime of Sri Lanka, and also shareholder protection and shareholder agreements. Without further ado, we will now proceed with the discussion. According to the Cambridge Dictionary, a shareholder is a person or an organization that owns shares in a company. But let's dive deep. May I now pose our first question to Mr. Nihal Jayawardena, President's Counsel. Sir, what is the historical underpinnings of the concept of a shareholder? So kindly unmute, I think.
Yep.
Thank you.
Shares in a company brings funds into the company. So when the concept of limited liability companies were created in the 19th century, this the new concept of shares was brought into the sphere of company law. It had to serve a similar purpose to that served in the case of a partnership where partners had to bring in money. But since the creature that has been created as a company had to be divorced from the people who brings in funds, the nature of a share had to be a different kind of a instrument, so to say. And this was discussed long time back in the case of Ball and Trustees versus Steel Brothers in the year 1901, where the share has been described as an interest of a shareholder in the company measured by a sum of money for the purpose of liability in the first place and of the interest in the second. So that created a situation where the contract contained in the articles of association with the person who has contributed to the shareholding of a company that a share is not a sum of money but an interest measured by a sum of money and made up of various rights contained in the contract, including the right to sum of money as dividend. Section 49 of the present Act recognizes that the share of a company is a movable property. That is a statutory recognition that has been given now by this Act itself. But throughout, a share was considered something that can be possessed by the holder of that share, and that person will have rights in and against a company. So that is how this share, the concept of a share has developed, and a share that has been acquired by a shareholder would usually confer the right to one vote on a poll at a meeting of the company or any resolution. Then the share entails another. These are the three main rights of a shareholder: the rights to equal share in dividends paid by the company, and right to an equal share in the distribution of surplus assets of the company in liquidation. So that's how the share, the legal status of a share is described. This was even in a recent case in 2003 in the case of Inland Revenue Commissioner versus Laird Group PLC. The interest of a person in a company, that the interest being composed of rights and obligations which are defined by the Companies Act And I, of course, have slightly edited the original version by saying that Companies Act and by the constituent documents of the company. Because now there is only one constituent documents as per our Companies Act, which is the Articles of Association. So the rights and obligations in the company, or interest in the company, or rights against the company are defined not only in the Companies Act, but particularly in the articles which is considered in terms of section 16 of the Act as the contract that exists between the shareholder and the company. So I think that could be a proper introduction into the concept of a share. And I hope that answers your question.
Thank you, sir. Yes, indeed, it clarified and then you gave an introduction, overall introduction of what and how a shareholder, the concept of shareholder came about. So my next question to you, sir, is what are the types of shareholders and what is the role of a shareholder in a private and a public corporate?
Now, there might be different types or different classes of shares, which would entail different rights. Now, the shares that I described in general earlier would be an ordinary share, or a share that the shareholder is willing to take the business risk in a company. If the company does well, the shareholder is benefited. Ordinary shareholder gets the benefit, but if the company fails in its business endeavors, then the greater risk is to the ordinary shareholder. Now, the rights that I mentioned earlier are akin to an ordinary shareholder, and now there can be different types or classes of shareholders who may have varying rights to those basic rights that I described before. For instance, there might be certain shares which would have a preference right, particularly with regard to the payment of dividend. There are other areas where they would be given preference, but I do not want to describe all those things. But for easy of description, I would take preference shares where the preference is in respect of dividends. So in that kind of a classification or a different class of shares, the dividend payment, in payment of dividend, those shareholders would be given preference to an ordinary shareholder. There might also be shares which are redeemable. Now, redeemable shares also fall into three different categories: redeemable share at the option of the company, at the option of the shareholder, and at the option or on a given date. So those are matters that would be addressed to in the Articles of Association, and the rights pertaining to redeemability will be discussed in the articles. So when one contributes into that share, the contribution to that share would confer him with those rights. So redeemable, then there can be non-redeemable shares, preference shares, redeemable or non-redeemable. So that there will be two different classifications there. Then you may confer limited or conditional voting rights, or you can confer no voting rights. There can be shares issued with non-voting rights. non-voting redeemable shares, non-voting non-redeemable shares. So when you look at this classification, you can see that there are shares that can be classified into various different classifications. What was the other thing that you asked, Larani?
The question is, of course, the types of shareholders and the role of a shareholder in private and public.
Right. Now, role of a shareholder is to contribute primarily to the capital of the company. Company issues shares. When the company issues shares, the shareholder acquires shares, and the consideration, which is a must for a share, the shares cannot be issued without a consideration that has been statutorily recognized by this act. And once the consideration is paid, on the original instance, when the company issues shares, the shareholder, the person who acquires the shares becomes the shareholder, and he acquires the rights that are recognized by the act and the company's articles, which creates the contract between the company and the shareholder. That is how he acquires rights in the company. Now, if a person contributes to the shares of a company thinking that the company will confine itself to a certain type of business, which prior to this act came into force was stated in the articles of association, because at that time, memorandum of association, at that time the constituent documents were twofold. One had the company's details and the object clauses, and presently memorandum of association has been done away with. Articles would state the objects for which the company is incorporated. The difference between this and the previous one is that prior to this act came into force, the company could only engage in the objects for which the company has given power to engage in. So when a shareholder became a shareholder of that company, he knew that the company has been established for the limited purposes stated in the object clauses in the memorandum of association. If the company tries to do anything more than that, that would become illegal and void in law. But now this Companies Act has completely changed that concept which was there earlier. Section 2 of the Companies Act permits the company to engage in any legal activity. When the company is permitted to engage in any legal activity, restriction that existed under the previous regimes cannot be enforced. Or, in other words, even if object clauses are stated in the articles, that per se will not limit the ability to engage in some business which is outside the objects of that company. Now, then in that event, why do we state the object clauses in the articles? That object clauses, as very clearly described in section 16, creates a contract between the company and the shareholder therefore would be able to enforce the conditions of the contract that exist between the company and the shareholder. So if the company tries to do something outside the object clauses or outside the objects for which it has been created, then section 17 subsection 3 can be invoked, and the company a shareholder has the right. A shareholder who does not want the company to engage in that business can go to court and obtain an restraining order in terms of section 233, restraining the company from doing what it expects to do outside the object clauses that have been laid down in the articles. But the difference with regard to the previous position and this is that it is not illegal for a company to do something outside the object clauses. And if it has already been done, that is another thing. If you go to court in order to obtain a restraining order, you should be quick enough to go to court prior to the activity which contravenes the object clauses has been carried out. If it has been carried out already, then you can't stop it. Then there are other remedies that could be enforced. Now, then you asked me about the shareholding of a private company and a public corporate. Private company can be a smaller private company or a larger private company. But whatever it is, if it is a private company, then the main difference between a public company and a private company is that in a private company, you cannot issue shares to the public, and a public company is a company which permits shares to be issued to the public. And if those shares are listed in a stock exchange, as reflected in the name itself, it will be a public listed company or a PLC. Am I clear, or did I answer your second question?
Yes, sir, you did. And thank you very much again. Let me now pose our next question to Ms. Ayomi Aluvihare, Senior Attorney at Law. Madam, in brief, what are the fundamental rights and duties of a shareholder?
Good evening, participants. The rights of shareholders are as set out in the Companies Act. There are rights that are attributable to each shareholder, i.e. each holder of a share. There are also rights that relate to a body of shareholders, and there are rights that spring from the body of shareholders, either a larger percentage of the body of shareholders or a smaller percentage of the body of shareholders acting in a particular way. The rights of shareholders are generally contained in articles of association, and as was mentioned by Mr. Jayawardena, the articles are a contract. So it is possible for the shareholders to decide on what their rights are going to be and include the agreed rights in the articles of association. So those rights, whilst they would flow from the Companies Act, would be rights that are specific to the investment that a shareholder would make. And it's not unusual, particularly in investment between different business partners, for there to be rights in relation to each investor that differ from one from another. And frequently when entering into, say, joint venture arrangements, you'd have shareholders who have sometimes equal rights, and they can be equal in one sense, but unequal in another sense. So Companies Act allows the flexibility to investors to decide on what their rights would be. The rights of shareholders in a public company can differ and does differ in a significant context. We a public company, we a private company. In a private company, the shareholders can agree that the company will act in a particular way that would even impact their rights. And if that decision is made and there's unanimous decision that is recorded in writing, then the provisions of the Companies Act are also excluded. So this is a flexibility afforded to a private company where the shareholders can agree by unanimous agreement in writing that certain rights given to them in the Companies Act will either apply in a particular way or that they will not apply at all. As I said, this is available only to shareholders of a private company. The relevant section is section 31. Again, as Mr. Jayawardena mentioned, the core rights attributable to a share and as such to a holder of shares is set out in section 49 of the Companies Act. And this is perhaps known that every share gives a right to an equal dividend paid by a company, and the norm is the equal dividend. But again, as mentioned, it is possible for shareholders to decide that one shareholder, one group of shareholders would have a preferred dividend to other shareholders, and it's not unusual to have in a company several classes of shares where each class would have a different dividend return. The Companies Act also allows agreement to be entered into between shareholders where the dividend return is unequal. But generally, a shareholder would have a right to an equal share in dividend. A shareholder also has a right to one vote on a poll. Having said this, again, it is possible for shareholders to agree, for example, that one class of shareholders would have weighted voting rights. I advise a company where one class of shareholders has 51% of the shares of the voting rights of a company at any given point. So the special class of shares, by virtue of holding the special class of shares, irrespective of the number of shares, that class of shares has over 50% of the voting rights. So an equal one vote per share is the norm, but it is, as I mentioned, possible for shareholders to agree that a particular class of shares will have a weighted voting right. The third right is the right to an equal share in the distribution of the surplus assets on liquidation. Again, this is a norm, but a variation can be agreed on. In addition to these rights that I refer to as the core rights, there are a number of other rights that shareholders, by virtue of their holding, are entitled to. One important right is the right available to a minority to, in certain instances, have the company purchase its shares. It's referred to as the minority buyout rights. And essentially, those rights flow from the decision-making powers that shareholders have. And I will touch upon this in a bit. But where the majority has made a decision in particular instances, and the instances are where there is a major transaction which requires a special resolution by shareholders, or where there is an amalgamation, again, that requires a special shareholder resolution by shareholders to give effect to an amalgamation. In these instances, where a minority dissents and votes against this decision or this action by the company, it is possible for the minority to require the company to buy out its shares. This is referred to as the minority buyout right, and this is available, as I mentioned, to any minority shareholder. Now, how do shareholders exercise their rights? As you know, in a company, you have the apex body, which is the shareholder, the shareholding. And you also, under the shareholder body, you have the management, the board of directors that are appointed by the shareholders, and the day-to-day management of the company is carried out by the directors. So how is it that shareholders exercise their rights? the Companies Act contains provision on how shareholders may exercise their rights. It's contained in express provision, and they can do this by participating in shareholder meetings or by resolutions in writing of in lieu of a meeting. So essentially, a shareholder exercises its rights by way of decisions that it is called upon to make. Now, these decisions are generally made and exercised as a group, as I mentioned, in shareholder meetings, and this is done by simple majority. Now, examples of exercise of rights through a meeting would be the right to appoint a director. Shareholders have a right to appoint directors, and this is done by the body of shareholders by simple majority. Another example is the appointment of auditors. The appointment of auditors again is done by simple majority of decision by the shareholders. Certain matters require shareholders to make a decision by a special majority. And the special majority, if it is not a simple majority, is a majority of 75% of the shareholders, and that is of the shareholders present and voting at a meeting. So it is not 75% of the total shareholder body, but those present at a meeting and voting. So the amendment of articles, decisions on major transactions, an amalgamation, as I mentioned before, changing the nature of business, require a decision by shareholders by special resolution for the company to act on such matters. Similarly, another instance where the shareholder exercises its powers pursuant to its rights is where the rights are to be changed. Now, it is possible for rights attached to shares to be changed, but this can only be done if the shareholders who are interested, i.e. shareholders in an interest group, decide to make the change pursuant to a special resolution of that interest group. So the shareholders acting as a group in decision making in particular instances is what I just touched on. Matters shareholders have rights or powers as a body. In addition to the two instances I mentioned, a hold of 5% of the shares or 5% of the holders can requisition a resolution to be passed at a meeting. So essentially, generally, a meeting of shareholders is convened by the board, but it is possible for a hold of 5% of the shares or 5% of the holders of a company to call for a meeting, for requisition a meeting. 5% of the holders or 5% of the shares can requisition the passing of a resolution at an EGM. Calling for a meeting is a majority of 10% of the shareholders. In addition to these rights that I have mentioned, if a shareholder acquires over 90% of the shares of a company, that shareholder has the right to force out or buy out the minority. This is the right entrenched in Section 246 of the Companies Act, and it is applicable only where, pursuant to an offer, investor acquires over 90% of the shares of a company. In such an instance, as I mentioned, that investor has the ability to acquire the balance of the shares. So these are largely the rights exercised by shareholders as a body. And as I mentioned, different percentages of holding is relevant in the exercise of those rights. In addition to this, a shareholder has a right to inspect company information. And of course, there's a corresponding duty on the company to provide the information, inspect the minutes of all meetings, copies of written communications between the company and the shareholder, certificates of directors, and the interest register. In addition to this, a shareholder has a right to receive information, and this information is the financial statements and the annual report, which contains prescribed information that the company is obliged to provide to a shareholder. So this is, Lalini, an overview of the rights of shareholders.
Thank you, madam. And on the same note, could you please elaborate the Sri Lankan law on the general liabilities and powers provided for a shareholder? Anything additional to what we've discussed?
Okay, certainly. Now, the fundamental feature of a company is that a company is a distinct person. It has a legal personality, and the person is created by the Companies Act. And it means that a company has a legal identity, and that identity is distinct from the investor or the shareholder. Now, given this very special nature of a company, the liability of the company is ring-fenced to the company. And other than in certain exceptional situations, the liability of the company and for the conduct of the company in carrying on its business does not become the liability of the shareholder. And this legal feature is the reason why, when the question is asked, what is the best legal entity by which I might carry out business, we would frequently advise that it be done through a company. Having said that, the shareholder, and again, Mr. Jawad referred to this, shareholder is liable to contribute to the assets of a company as contained in the Articles of Association. Typically, Articles of Association do not have such a provision. And if so, the obligation of the shareholder is to contribute to the capital. And once a contribution is made, there is no further liability. Now, it is possible for a company to issue shares without payment being made by a shareholder, referred to as issuing shares on call. And in such an instance, a shareholder is liable to pay for the shares as and when the company calls upon the shareholder to pay for the shares. So the liability, by and large, of a shareholder is limited. There are certain instances where a court would look at a company and the shareholder and the conduct of the shareholder and the company and decide that though legally the company is a separate entity, the conduct of the shareholder has been such that liability of the company is attributable to the shareholder. And these are instances where there is fraud, there is improper conduct, but these are exceptions. I'm only touching upon this. There are many cases. For example, it's not possible for a shareholder to evade a contract or tax liability by setting up a company. It's an instance, and there are decided cases where the court has looked behind, and there is a reference to a corporate veil, a notional veil that separates the shareholder from the company. And in these exceptional instances, court has lifted the veil or pierced the corporate veil to hold the shareholder liable. There is another instance where if a distribution is made by a company and the solvency test has not been satisfied, the company is able to recover the distribution from the shareholder. And if in such an instance, the shareholder will be, of course, liable to return the funds. Again, there are exceptions. If the shareholder had no knowledge, etc., the liability does not arise. But the general principle is that if the solvency test is not met and a shareholder has received a distribution, a company is able to claw the distribution back. That is sort of an overview of the liability, of a possible liability of a shareholder.
Thank you, madam. Our next round of questions will be for Mr. Hirandi Alvis, Senior Legal Counsel. Sir, what are the shareholder protection available under the current legal regime in Sri Lanka? So kindly unmute your microphone.
Am I clear? Thank you. Yeah. Good evening. Thank you, distinguished panelists. With your permission also. May I, yes, now firstly, I would like to emphasize, if I may just diverge, now we are speaking to a non-lawyer audience, I believe. So I was wondering what we are doing on a Wednesday, Tuesday evening. But what I want to emphasize is to the corporate community that the law provides a sword and a shield. So it's up to you to make the maximum of this, what the law provides. For example, I think our business community also has a lot to learn from, for example, of American counterparts. If you see, for example, even with Bill Gates and his money he makes, it's mostly on a licensing agreement. Same way, in Sri Lanka, I'm happy to state that we have, in fact, quite sophisticated laws, especially even in the realm of Companies Act. So shareholders of companies and who want to get into business have, in fact, the opportunity of protecting their rights and expanding their profits, knowledge, etc. I will go into that later if there is time. Getting back to your specifics, really. Now, a shareholder is actually somebody who is registered in the company's register. That is, so that's how you become an owner. A share, in terms of the Companies Act, is a movable property. Now, it is a monetary unit in that company, and there are various rights that accrue to you in terms of the articles and the Companies Act. So shareholders have statutory rights, contractual rights, and certain equitable rights. So one of the principal ingredients, I believe, in a company share is the right to transfer that movable asset. This is one of the fundamental and perhaps the most important characteristics of a company. And in fact, you are entitled to transfer your share even to a man of straw, subject to sometimes restrictions in an agreement you have where the right of offer is made to existing shareholders exact. But that is in fact something very salutary. Now, it is also another option where a shareholder in a company who is dissatisfied in the manner the company is run can actually withdraw their investment by selling their shares to the public. So if it's a public company, it's easier. It's private company, you might have to find a buyer, or there might be some restrictions. So litigation is the next option. Specifically in terms of the act, if I may, just going to the philosophy behind this, I think Nihal was mentioned. One of the brilliant creations of the law, I believe, is the establishment of a legal liability company. This led to the growth of business because people can take business risk and invest, generate profits, employment, etc. Same way, a share is recognized statutorily. So there are different types of control in modern companies. You can have the majority who control, say maybe over 51%, or if you have a block of share. Minorities can control. You can have control through the management, or you can have control through legal devices such as trusts, sometimes golden share, etc. Now, this legal fiction, which I said, is recognized in our Act in Section 2. That is also recognized in the in England, as you know, the law was developed in a famous case called Salomon. So without going into specifics, in toto, we have the protections available in our act. But this is, in fact, has been there for a while. We have the Companies Ordinance from 1938. We have the civil law references in 1853. Now we have a modern Companies Act 2007. Some might say it's too sophisticated for Sri Lanka, but in some ways. But what I want to emphasize to the American Chamber and in fact the business community is you have the protection and the weapon to go ahead with your businesses. Now, also going forward, there will be, for example, people are looking at joint ventures overseas, foreign trade, this real investment trust, for example, slightly different, but anyway. So what I would like the American Chamber also is to see is to develop this financial literacy amongst the business community, that there is in fact very sophisticated legal protection in our laws. Now, how do you enforce the existing rights? How do you enforce? What I believe is, what is lacking is our regime is not the law, but effective enforcement of the existing law. Now, for example, even prior to going to litigation, you can, as Mr. Ayomi said, shareholders can requisition a meeting or a resolution. You can write to the company. You can write to the company secretary. You can request audited accounts. You can request for AGMs to be held. You can ask for board seats, etc. You can request for dividends, though it's not mandatory. You can express your intention. You can ask for the share register to be updated. So all these are there embedded within the Companies Act. Now, in specific statutory remedies are also there. For example, Section 224 onwards of the Companies Act allows for protection against oppression and mismanagement by the majority shareholders. You have derivative actions. You have the power to get restraining orders through the Companies Act. So, with these powers in the Companies Act, for example, a court can order board meeting to be called. For example, there might be a situation where there is no quorum. So a court can intervene. Then another unused provision is where you can have the registrar of the companies, the Director General, to have an inspector appointed to investigate the company. For example, the registrar can make a report to court. A complaint can be made as to the ownership structure, securities, assets and liabilities. So either directly through the registrar or through the courts. Now, so these provisions are there in our Companies Act. Now, this derivative action, which is also available now statutory in our Act, is where it's a slight exception to the normal rules, where shareholders can bring an action on a representative basis on behalf of the company if there is a fraud on the minority. So this has been recognized by case law in Sri Lanka, now statutory. Again, I would advise the business community to, going forward, if you have an issue, it is a well worth investment to get proper professional advice. I'm not trying to promote lawyers, but with all due respect, this is one of the drawbacks in our business community, with great humility, I must say, where we can learn, especially from our American counterparts. They have a very, very good knowledge of the legal system. You sign a contract, you can be sure they will use that not to defend themselves, but in fact to get rights accruing to themselves. I was referring to the Microsoft story. For example, so we also have this bad practice of signing documents without possibly even reading it. So my advice is you go to your professional advisor and obtain very specific remedies which you have in the law. I'm not talking only of going to litigation, which is an option that is there right at the end. Now, specifically under these provisions of oppression and mismanagement, if there is minorities, shareholders sometimes feel that there is oppression and mismanagement. Now, this is one topic which is quite often spoken about. Just to delve on the other side, it is also important for majority shareholders how to control your company. So we can't get into it, but you should be smart enough to utilize the powers given to you in the articles and the Companies Act to get the maximum benefit if you want to exercise your majority control. Now, for example, you need a 5% threshold to get into the courts to exercise your rights under minority protection. Now, for example, if there is what you say is oppression, in the oppression of the minority shareholders, it should be primarily in relation to their shareholding. For example, if exorbitant salaries are being paid to directors or to the controlling shareholders, or there is investment in their related businesses, you might be able to use these provisions. It is also salutary, or in fact, it is also important to note that courts generally should not and will not interfere in business policy. Courts are not there to run companies. So it is up to you to fashion your case so that you come within those specific areas. Then if there is mismanagement of the company, for example, if they are acting against the interests of the company, or if there is a material change, for example, change of the board composition, ownership of shares, there is huge discretion granted to courts to intervene. And do not forget that courts go into almost a just and equitable basis of giving reliefs under this section. It may be salutary, it may be not, but owners or majority of the companies who have a majority stake should be very well aware. For example, court can intervene and appoint directors. Court can appoint a company secretary. Court can order a forensic audit. Court can terminate agreements. And it can grant wide interim reliefs. Sometimes it's dangerous, but there is also opportunities for redress. Depends on which angle you look at it. Thank you. With the time constraints, that's how we can share it.
So I have another question for you, sir. What is the importance of the shareholder agreement and how does it supplement the existing statutory and corporate governance regime we have in Sri Lanka?
Thank you. That's also an important area in Sri Lanka. For example, one must be extremely aware of this distinction between the shareholders agreement and the articles. There is, for example, the articles are the primary constitution of the company and governs the internal management. I'm not going to elaborate on that because distinguished speakers refer to it. But it's important to note that this is a statutory provision. So the Statutory Companies Act takes precedence over a shareholders agreement. Now, companies have legal personalities. Now it's increasingly governed and regulated by codes of regulations and the courts. Therefore, parties may wish to express their private intentions and plans by way of a shareholders agreement. Generally, it is a meeting of minds prior to deciding how we are going to form a company. So, for example, joint ventures, creating a new business. If you have family intentions you want to put in, a trust, representations on the boards, etc., how to dispose of shares, you can put all those things in a shareholders agreement. I would also sometimes advocate putting whatever is there in your mind into the shareholders agreement. Whether it will be enforced or not is a different question, but if you want to do that, put it in. If nobody challenges it, it's good for you. So shareholders agreement is a contract. If you breach it, there is remedy in damages. However, be extremely cautious. Shareholders agreements sometimes are governed by different laws. It might be a different choice of law. There might be an arbitration agreement. So be extremely cautious. You might be caught up in a local party who will having arbitration clause in France or USA, or a choice of law in another country, without realizing that in fact you are doing business. Again, I would advise get some proper professional advice. One of the other important defects which we have is parties look at the shareholders agreement, come to a meeting of mind, have their honeymoon period of sweet talk, forget about the memorandum and articles. Ultimately, your company is governed by the articles, especially in the present era. So do not forget that. Now, if you cannot also put intentions in a shareholders agreement, for example, which goes against the company's. There was a famous case called Russell, can't go through it now, where a bank loan not to increase capital was put in, but they said after over 10 years, the company's act provides for that. So those was held to be invalid. So as I said, enforcement, you can enforce the shareholders agreement even against the company if the company is a party to it, provided it's not in conflict with the Companies Act. Then very briefly, shareholders agreements subject to laws of contracts. I want this thing. Other remedies for that. As you say, breach of contract, you can claim damages through the shareholders agreement. You can have specific performance of the shareholders agreement by going to courts to enforce, for example, a sale of purchase of land. You can also possibly get injunctions, possibly a mandatory injunction compelling a certain act. You might be able to terminate and exit in terms of the shareholders agreement. And another very, very important area I would advocate is when you are having a shareholders agreement, please look at the exit clauses. There possibly as the initial shareholder, you will be giving personal guarantees, indemnities, where you exit, try to obtain an exit of those personal guarantees, if it's possible, or to get a corporate guarantee to cover the liabilities to third-party banks, etc. So it's up to you if you can incorporate those into your shareholders agreement. So again, exercise due diligence. Thank you.
Thank you for that insight. And our final question for the day is for Mr. Jayawardena. Sir, can a shareholder be a director? So please unmute the microphone.
Since this is meant for mainly non-lawyers, as mentioned by Mr. Iran Rodrigo, that there are few misconceptions with regard to shareholders and directors, and they mix up these things. Who a shareholder is and who a director is often misunderstood by the layman. And the shareholder is, as I mentioned earlier, the person who contributes into the share capital of the company and creates a kind of a contract based on the constituent document. And in the initial stages, for you to become a director, you had to become a shareholder of the initial stages of company law at the very beginning of the development of company. But it has come to a situation where a person without even a single share can become a director of a company. So earlier there was this qualifying shares to become a director, that is also not a must, but if the parties intend to do that, that also can be done, not in all companies, but in a private company. And the simplest answer to the question that you asked is that a shareholder can become a director, and it is not necessary always for a director to be a shareholder, because the roles are completely different. The directors would direct the business direction of a company. They take policy decisions as to what the business direction of the company should be, and thereafter they oversee what's happening in the company, and they take decisions pertaining to the forward march or the way forward of the company. They would be the directors would be the core lifeline or the decision makers of the company, and also they will make their decisions based on the information fed by the company's key officials. So the answer directly to the question that you posed from me is that a director certainly can be a shareholder, or in other words, a shareholder can certainly be a director and can go on with this decision-making process. Now, in small-time companies, private companies, usually shareholders become directors and they carry on with the business. But when it is a larger business concern or a company or a business concern operated in the form of a company, the directors are being appointed by the shareholders and they are removed, as Ms. Aluhare mentioned. The directors are appointed and removed by the shareholders by way of a simple majority decision taken at meetings, and the appointment is by way of a resolution. That resolution, usually to appoint a single director, there has to be one resolution, unless you have previously resolved to have several directors appointed by one resolution. So that's how it works. I don't know whether I have answered the question that you have posed me.
Yes,
I
sir,
hope
indeed.
I have done.
Thank you.
Yes.
And to conclude today's session, let me now invite Naomi Aluhare for any closing remarks. Madam, over to you.
Thank you. I think from the point of view of a business, the greatest attraction in investment is the flexibility that the Companies Act affords. Something we didn't, between the three of us, mention is that the 2007 Act is based largely on the English law yet, but brought in provisions from the New Zealand Act, particularly the capital provisions from the New Zealand Act, which are provisions based on the legal provisions of North America. The flexibility in dealing with capital is what we see in the American statutes as well as the Canadian statutes. And that is, in fact, in the changes that came in 2007, one of the most useful changes. So from an investment point of view, there is a great amount of flexibility in how you structure your investment when you make it in a company, and that includes structure in the return as well as your involvement in management. So I would conclude with that comment.
Thank you, madam. And Mr. D. Alvis, would you like to share any closing remarks?
Yes, with a controversial comment, whether you agree or not, I think a share is in fact an egalitarian concept. It enables sharing of capital. So it's a great tool, actually, like a shareholding democracy. You have a capital earning class. So it's a huge opportunity, not only to develop the infrastructure of the country, but even the wealth of the people. Thank you.
Thank you, sir. And to Mr. Nihaja Wadana, sir, would you like to also add a closing remark?
As my two colleagues mentioned earlier, this present act, which is based on the Canadian Act primarily and then structured on the New Zealand version, because there was a New Zealander who was involved actively in the reforms process. Therefore, this act provides a greater flexibility and protection to those who contribute to the shareholding of a company, and that I think would be a greater message that you could carry out to the potential investors who would like to invest in shares of our companies, and also bring capital in the form of FDIs to this country.
Thank you, sir, for that thought. And this concludes our session for today. On behalf of the American Chamber of Commerce in Sri Lanka, I take this opportunity to thank the three eminent panelists for graciously accepting our invitation to participate this occasion and sharing their valuable thoughts and insight on this contemporary topic, given the dynamic changes taking place. Bidding you all a pleasant evening, and over to you, Rai.
And thank you, of course, to each of our eminent panelists. Your thoughts and your insights were, of course, appreciated as always. And I believe when we follow up with the article, which we usually do, there'll be, highlighting of everything that you've said in a more digestible form, so that as you mentioned, the difference between speaking to a legal community and speaking to a layperson. So when we put it out as a publication as well, I'm sure that will be much appreciated by our membership. As you know, the AmCham Legal Review Series is created and curated to provide insights into contemporary and topical legal issues, especially given the volatility and the continuous kind of disruption in the business arena in today's environment. Thank you once again to each and every one of you, and of course to all of our viewers on Zoom, on Facebook, and on YouTube as well, for taking the time, as well as for sharing your thoughts and your questions. We've run out of time, and for that reason, any questions that have come in after 7:35, we will share with the panel by email. And if they have if they're able to share their thoughts with us, we will certainly forward it across back to our viewers. Thank you once again. Wishing you all a very good night, and do stay safe and limit exposure. At the end of the day, it's up to us to stay as safe as we can and to ensure that our loved ones are safe as well. Thank you, everybody. Good night and God bless.